guys, this is Shubhi this side, and today we are going to learn about a very interesting and important topic. A topic which each law student or a commerce student must know, and it is important as well. So we are going to study today about doctrine of ultravirus. Now, what do you mean by doctrine of ultravirus? Before I tell you that, let me remind you, आपने हर क्लास में किसी ना किसी फैकल्टी से सुना होगा कि अगर कोई भी कंपनी कोई भी ऐसा एक्ट करती है which is ultra virus, it can go beyond the power or it is null and void. So yes, the doctrine of ultra virus, and just a second, the pronunciation is not doctrine of ultra virus, that is doctrine of ultra virus. So be apt with the pronunciation before you use it. Now, before explaining you the whole law, let me tell you and divide these words into separate parts and tell you the exact meaning of each word in this magazine. When I talk about doctrine, डॉक्ट्रिन मतलब होता है थ्योरी, दैट इज सिद्धांत. किसी भी चीज के सिद्धांत को, किसी भी चीज की थ्योरी को वी से एज डॉक्ट्रिन. If I talk about ultra, it means something which is beyond, which is not right. And when I talk about vires, it means powers. So if I say something which is beyond powers, that is ultra virus. So yes, we are talking in the context of a company. So जब भी एक कंपनी बनाई जाती है, it has some limitations जो हम अभी आगे डिटेल में देखने वाले हैं. So definitely if a company goes out of that limitation, out of that powers, the act is known as ultra virus. And even if the contract is done, which is ultra virus, it is invalid and it is null and void. It will be not binding on the company. Now, what we are going to see further in this video, we are going to see the basic meanings of doctrine of ultra virus, the effects, that is, what if a company goes into a contract which is ultra virus, and a relevant and referred case law about the same. So let us understand the basic first. जब भी एक कंपनी born होती है, जब भी एक कंपनी birth लेती है, or in a law language I can say that whenever the company is incorporated, the first thing a company does even before incorporating is making memorandum of association and articles of association. Memorandum of association is a very important charter document which is a binding document जो कंपनी की limitations, कंपनी के powers बताता है. It tells you the constitution of the company. जैसे as a Indian citizen हमारा constitution हमारे rights बताता है, वैसे as a company जो constitution है कंपनी का, that is all memorandum of association. And whenever, the most important thing, there is a fight between MOA and AOA, MOA will always override AOA powers. So in short I can say doctrine of ultra virus is very important and has to be in permission with, in association with memorandums. If a company does anything which is beyond company's powers, which is beyond memorandum, so that act is invalid, that act is null and void. As I have told you, you might have understood the meaning of doctrine of ultra virus. So who is bounded to this doctrine, to this memorandum of association? The company makes this memorandum of association for itself to see the limitation and powers. एक member जो है company का, जब भी वो share में invest करेगा, उससे पहले he must understand the MOA and AOA of the company and the outsider as well. Yes, because whenever you are doing a contract with the company, you should know the limitations and powers of the company. How can you see this memorandum and article of association? For your knowledge, memorandum and articles are the public documents. If you are going into a contact with the company, you can ask them a copy of MOA or AOA, or with very nominal fees, ROC also provides you in MCA website the copy of MOA and AOA as they are the public documents. So that we know what is the limitation and power of the company as a member, as an outsider, or the company itself. So first understand what is the effect if the company does anything which is beyond the company's powers. The first thing is any member means any owner, any shareholder feels that company is doing anything which is beyond company's powers, that is the act which is ultra virus, they can call for injunction. What do you mean by injunction? किसी भी अथॉरिटी, किसी भी हायर अथॉरिटी से ऑर्डर देना, किसी भी हायर अथॉरिटी को रेगुलेटरी एक्शन लेने बोलना, दैट इज कॉलिंग फॉर इंजंक्शन. सो द मेंबर कैन ऑलवेज गो इन द कोर्ट and ask for injunction. Second, whenever you do any contract, for example, if a company is expelling the member, कोई डायरेक्टर है वो किसी मेंबर को एक्सपेल करता है, so this is null and void because the memorandum is not giving the permission to do so, and thus the contract माना जाएगा कि वो हुआ ही नहीं है. The contract will be declared as ultra virus, means null and void, invalid. What if अगर डायरेक्टर कोई काम करता है which is outside the scope of memorandum, so क्या आप कंपनी पे केस कर सकते हो? नहीं. आप कंपनी पे केस नहीं कर सकते because the memorandum is not telling about it and this is ultra virus, but you can definitely case personally to the director. You can sue the directors personally and they will be personally liable for the same. Okay, and there is very interesting case laws, that is Ashbury Railway Carriage and Iron Company Limited versus Rich. 1875 का केस है, बहुत इंटरेस्टिंग और बहुत फेमस केस है. If you want to know the detail about this case, I am going to add a separate video on all the analysis and conversations between Mr. Rich and the other related parties. But मैं आपको भी short में बता देती हूँ what this case is about. Basically, Ashbury Railway Carriage एक railway company है, उनको टेंडर मिला था और उनने ये जो टेंडर है वो रिच को दे दिया, फिनेंस कर दिया, टेंडर भी दे दिया एंड उनको लोन भी फिनेंस कर दिया. जब कंपनी की मीटिंग हुई एशबरी रेलवे कैरेज की, तो शेयर होल्डर्स ने ये कॉन्ट्रैक्ट मना कर दिया ऑन द बेसिस ऑफ डॉक्ट्रिन ऑफ अल्ट्रा वायरस, दैट ये जो आप फिनेंस का काम कर रहे हो ये हमारी कंपनी अलाउ ही नहीं करती है बिकॉज इट इज नॉट इन द मेमोरेंडम दैट यू कैन फिनेंस समबडी. सो एशबरी आस्क्ड रिच टू गिव द लोन बैक. रिच डिनाइड. In this case, Ashbury has sued Rich and the Rich lost the case on the basis of doctrine of ultra virus because ये contract हुआ ही नहीं, ये contract ultra virus माना जाएगा, it is invalid. But the court also suggested Rich to sue Ashbury Railway Carriage Limited's MD and director जिसने उसको contract दिया in the personal capacity. So at the end, I hope you understood that anything which is done beyond the powers of the company, anything which is done beyond object clause of the company, anything which is done outside the memorandum of the company is doctrine of ultra virus, means that is the act which is null and void, the act which is invalid. So stay tuned for the detailed case law analysis. Thank you so much guys.